Hello friends, welcome back to VOW DAYS. Welcome to the mains test series discussion, and this is test 9 of mains, and this is part 1 where we will discuss the first set of questions, first 5 questions in fact. And before we begin, a small information: the document that we are using is the summary document that VOW DAYS has prepared from the Vision test series. As you all know, Vision provides solutions for each and every test, and this solution is a bit long. So we have tried to concise this solution of 50-60 pages solution into just about 10 pages. So why we have done this is to make things easy for you, so that you will be able to revise the similar content, revise the same content in fact multiple times. Okay, so do make the best use of this. This will even help you in your state PSC as well. Now let us quickly start with the first question. So first question is with regard to the Interstate Council. So the Interstate Council basically is a council where all the states and the center come together and they will discuss on the common matters. So states raise demands with respect to the need for taking their views on the bills of national importance which are placed in the parliament and that are likely to affect the interest of the states. So basically this is talking about the bills being placed in the Interstate Council. That means even this Interstate Council will be discussing the bills which affect the interest of the states. Okay, normally the bills are not given to anyone, but they follow the rules. So the states now want to discuss these important bills in the Interstate Council. That is what is the demand. This Interstate Council is a constitutional body under Article 263, as we all know. Now the reason for such demand, the reason why such demand is coming is the states feel that the government of India is sidelining the collective opinion of the state assembly. Example, if you see in the bifurcation of Andhra Pradesh and Telangana, the Andhra Pradesh assembly then outrightly rejected the bifurcation, but the parliament went on and it has bifurcated the state. So the state resolution does not have any importance in that case, but the states have to be given importance because we are a federal country. The states also have some value, so that's why. Next, hasty passage of bills. Example, the tribunal reforms bill, Aadhaar bill, okay, even the land reforms bill. So all these bills, hastily they are being passed. They are not discussed adequately in the parliament. Article 253 empowers parliament to make laws for the whole or any part of India for implementing any treaty, convention with any country or countries or international conferences. And Article 249, it empowers the parliament to enact laws on a state list, often receives the backlash from the states for uprising their powers. And the lack of coordination among the executives of the state and the union leads to the filing, litigation and delay in the implementation of bills. So to bridge this trust deficit, to bridge this gap, this kind of thing will be helpful. And also according to the PRS, the percentage of bills referred to the standing committees, especially the department related standing committees, has decreased from 71% in the 15 Lok Sabha, that is 2009 to 14 to 25% in 16th and 13% in the current 17th Lok Sabha. And so basically this is very important because the Interstate Council actually, it will strengthen the federalism. The aim is to promote cooperative federalism. It is to ensure that there is some cohesion between the center and the states. The issues will be discussed and solved, and also to increase the state cooperation and to bridge the trust deficit. But there are certain issues in introducing the bills in the Interstate Council. First is there is no dedicated administrative mechanism with the experts to study the bills, and also the Interstate Council does not meet frequently. Though it's a constitutional body, it will be constituted by the president. So it's not a permanent body. There is no permanent secretariat also. And the current composition lacks representation of MPs who otherwise takes part and express their votes in the parliament. So the Interstate Council does not have MPs, but the MPs are integral part of parliament, and it is the parliament that has the decision making power. And also the debate on bills at the Interstate Council and the parliament may delay the bills further. This is also an issue. And Interstate Council itself has some other issues. The Interstate Council is not held regularly. They don't meet regularly. After 1919, they just meet 12 to 14 times. That's it. And all the recommendations are just recommendatory. The center does not have to follow the recommendations of the Interstate Council. And as I said, it is not a permanent body. Though it is a constitutional body, but it's not a permanent body. It is set up only when there is a need. There is no permanent secretariat for the interstate council. This is also an issue, right? So these are the broadly the issues with regarding to the interstate council and the bills being taken up in the interstate council. Now let us look at the second question, which is about the Directorate of Enforcement or Enforcement Directorate, how we call the ED. Well, in the recent times, the ED, CBI, all of them are in question. They are being targeted by saying that the central government is just using them for their political goals. So Enforcement Directorate is a multidisciplinary organization mandated with the investigation of economic crimes and violation of forex laws, and the administrative control is the Department of Revenue, Ministry of Finance. So this is the thing. Now what is the role of ED? The role of ED. So there are basically some statutory roles. For example, enforcement of the PMLA, the Prevention of Money Laundering Act of 2002, by doing investigation to trace criminal assets, to provisionally attach property and ensure prosecution of offenders and confiscation of property by special court. They also have the power to seize assets. And next is the Forex Management Act of 1999. The ED has to investigate suspected contraventions of forex laws to impose penalties on those adjudged by the contravention law. And power to summon. ED can hold inquiry against any person who has allegedly committed in contravention to these rules and regulations. Also, under the Fugitive Economic Offender Act of 2018, ED can attach the properties of the fugitive economic offenders. Next, the Conservation of Forex and Prevention of Smuggling Activities Act of 1974. So ED has to sponsor the cases of preventive detention with regard to the contraventions of FEMA. So this is the role of ED. But the ED has been criticized lately by the political parties. The ED, it is criticized as it is being weaponized under the PMLA by invoking strict provisions even in minor cases to put people behind bars. The central government is using it against their political opponents. It failed to ensure successful prosecution. The conviction rates are low. Between March 2011 and Jan 2020, ED conducted 1700 raids in connection with 1569 separate investigations, but only 9 of them resulted in convictions. So the conviction rate is very, very low. Also, there is lack of transparency and clarity in the investigations that they do. The FIR, what they file. So in FIR, normally we file FIR in police station, but in ED it is the Enforcement Case Information Report. This is not given to the accused. This is also an issue. Okay, so that is the thing about ED. But ED at the end of the day is very important organization. It's an independent organization which works to prevent the economic crimes, financial crimes, especially these the people who are doing money laundering, the people who are doing all the economic offenses. They have to be held, and the ED plays an important role in that. Right. So this is about the Enforcement Directorate, and the role is the PMLA Act. Remember this PMLA Act, the Forex Management Act, the Fugitive Economic Offender Act, and the Conservation of Forex and Prevention of Smuggling Activities Act. Like if you just remember 3-4 of them in the exam, it will make things easy for you. Next, the third question. It is about the liberal democracy. So, liberal democracy is the representative democracy wherein the decision-making power of the elected representatives is subjected to rule of law. So, rule of law will play a major role in this. So, Indian democracy is a liberal democracy because we have rule of law, we have a constitution that guides the lawmakers. Everyone is subjected to this rule of law. No one is beyond the constitution and the rules. So, Indian constitution in fact promotes this liberal democracy in various ways. First, it has linked the liberalism to the social justice. Example, the reservation for SC/STs and the number of special measures to protect interests of the marginalized sections, like the reservations in the legislature, the government services, education, etc. And the constitution recognizes the community-based rights. Example, rights of the religious communities to establish and run their educational institutions. Okay, and also we have uh, various commissions, in fact, the OBC Commission, okay, and even the CST Commission and all, the Women Commission. The constitutional makers ensured that the state is responsible or responsive to the need of the individual and provide them the means to communicate needs. That means the freedom of speech and expression, Article 19, and also Article 21, where no person shall be deprived of his life and personal liberty except according to the procedure established by law. And then the separation of powers. To prevent arbitrary exercise of power, the court can interpret and apply provisions of constitution without conformity with the legislature. And then the DPSP need the state to ensure conditions necessary for individuals to exercise autonomy and self-determination, and they are satisfied either directly by the state or through regulation of market and society. So through various ways, in fact, the constitution is promoting the liberal democracy. Through DPSP, it is guiding the state to ensure the socio-economic democracy. Through the fundamental rights, the constitution is guiding to promote the political democracy. But at the end of the day, if you see, overall there are some issues with regarding to the democracy as well, especially in the Indian context. The issues are, first is poor parliamentary debates, the parliamentary accountability, that is a major issue. The number of bills that are referred to the parliamentary committees, that is reducing. We just have seen. There is an issue with the economic democracy because the lack of opportunities, you can say, the lack of jobs, you can say, and also the increase in the disparity between rich and the poor, that is also an issue. The criminalization of politics, that is also an issue in our democracy. In the 17th Lok Sabha, more than 50% legislatures, they have the criminal cases on them. Next, poor representation of women. Poor representation of women in the legislature and in the economy. The ill practices which are still being followed. Caste is still an issue. The manual scavenging is an issue. All these are the major issues that we still have. But still, India is a vibrant democracy. The democracy is thriving in India. We can't point out at the democracy and the democratic values of India. Elections are held regularly. The rules are being valued by the people, even the legislators. Okay, everything functions according to the constitution. The Supreme Court currently is the guardian of the constitution. It is protecting the constitution and its values. So all of these things are there. So if there's a question, we can write all these points on this. Next, the fourth question is on the Central Information Commission. Central Information Commission is a statutory body constituted under the RTI Act of 2005. It helps in promoting transparency and accountability in the government functioning with various awareness programs and etc. So, if you see the positives of this commission, the first thing is it empowers the people through the information. It will ensure that the people receive accurate information under the RTI. It will ensure people receive information. Okay, it will ensure that the public offices, they don't delay the information delivering. This will increase the transparency. This will increase the responsiveness in the system. All of these things are there. But there are certain issues that are faced by Central Information Commission. The RTI Amendment Act 2019 removed the provisions with regard to tenure, terms of service and salary of CIC and Information Commissioners given by the RTI Act of 2005 and stated that the government will notify through its rules. So this is a hit on the independence of the commission. Poor record management practices leading to delay in the processing of RTI applications. Lot of delays and backlogs are still there in this. The Ministry of State for Personnel in July 2022 said that 26,500 appeals and complaints are pending with the CIC. There is issue with regarding to the appointment of CIC. The Act does not give adequate authority to issue directions to the public authorities to take steps to comply with the act, and they are not binding in nature. Also, there are no penalties on the public office if there is any delay. They cannot impose any penalties. For an institution like CIC, which is meant to democratize information, increasing in the number of case rejections is a cause of concern. Now, what are the measures that can be taken to strengthen the institution? What are the measures that can be taken? First is the selection should be transparent with respect to the direction of Supreme Court in the Union of India versus Namit Sharma case in 2013. The selection committee must put facts indicating that the recommended candidates are eminent in public life, knowledge and experience in the public domain. So this case you have to quote in the exam while writing the CIC. Abide by the 2019 order of Supreme Court, which ordered the government to start the process to fill vacancies 2 months prior to the post post when it is going to be vacant. Urgent digitization of records and proper management of these records. This is also very important because this will ensure that the steps are taken in the right time and there is timely delivery of the information. The obligation on information commissions to assist people in filing the appeals and complaints and not returning them to the deficiency. So all of these things can be taken. These are the measures that can be taken. Because at the end of the day, this is one of the important body that we have in our system, because this will promote the much needed transparency and this will empower the public with the information, and this information is something that is very, very crucial. Now let's look at the last question of the day, and the last question of the day is with regarding to the principle of subsidiarity. The principle of subsidiarity guarantee a degree of independence for lower authority in relation to higher body or local authority with respect to the government of India. It ensures that the decisions are taken as closely to the citizens and the constant checks are made. It has special relevance for India due to large geography and diverse needs of various regions, which can be addressed at local level. Now, what is the importance of the principle of subsidiarity? It helps democratic system derive full legitimacy and self-reliance at local level. There is high ownership of programs by the local community. There is change in flow of decision-making authority from top down to bottom up, and there is decrease in the transaction cost, delivery time and increase in welfare. Also, there is redesigning of center-state relations between the state and the local bodies such that there is true empowerment. Empowering the Gram Panchayats and Gram Sabhas to have greater say in the local issues related to water, sanitation, etc. Example, the Model Bill for the Conservation, Protection and Regulation of the Groundwater 2011, which seeks to implement the principle of subsidiarity, which involves an aquifer situated entirely within a village to be under the complete control and direct control of Gram Panchayat. Better supervision and monitoring of certain issues, example, exclusion of vulnerable families from social security, ensuring presence of teacher in village schools, etc. And enforcing social accountability via social audit of schemes such as Manrega is done by the Gram Panchayat. Even second ARC says that we need to redesign the governance on the basis of the principle of subsidiarity. But at times, taking matter to higher levels is important as it bears effective results such as the national program on polio eradication despite health being a state subject. Certain matters may have international repercussions as well. Example, the state borders touching the neighboring countries. So all of these things have to be considered while making the laws and rules. So this principle of subsidiarity, at the end of the day, it will decentralize, it will democratize the entire process. Decentralize and democratize. Because this will ensure that the lower strata or the people at the lowest level, they will get the decision making power. So when the people at the lowest level get the decision making power, then the local needs are met, and this is the major objective. Okay, this is the major objective, right? So these are the questions of the day. And if you have any queries or any questions, you can leave in the comments. We will get back to you. If you want to subscribe to our courses, okay, you can contact us via the email or via Telegram as well. So do let us know your thoughts. Do share the video with your friends, and do give your suggestions in the comment box as well. Thank you for tuning in for the day. We'll meet again tomorrow with the next set of questions. Till then, keep studying and stay tuned. Jai Hind.